When a company goes into corporate rescue, everything changes. The directors step back, creditors pause their claims, and employees wait for clarity. At the center of it all stands one figure, the corporate rescue practitioner. This role carries enormous responsibility because the practitioner becomes the steward of the company during distress. I am Calverwell, and I help SMEs manage restructuring and create the clarity they need to grow with confidence. In this session, we will look at the key functions of the corporate rescue practitioner under the Zimbabwe's insolvency regime, how they are appointed, their reporting duties, their powers and responsibilities, and the accountability they owe to creditors, employees, and the court. A corporate rescue practitioner may be appointed in two ways: by the board of directors under Section 122 through a resolution to place the company under supervision. In that case, the board must appoint a qualified practitioner within 5 business days of filing the resolution, or by the court under Section 124 when the affected person applies for corporate rescue and the court makes an order. In both cases, the appointment only becomes valid once the Master of High Court certifies it. The Master's role is not to choose the practitioner, but to verify compliance with the Act, checking that the appointee is registered, independent, and not disqualified, and has lodged the required bond of security under Section 131. This safeguard ensures that every appointment meets legal and ethical standards before the practitioner takes control. Not just anyone can be appointed. Under Section 131, a practitioner must be a licensed insolvency practitioner under the Estate Administrators Act, not be disqualified from acting as a company director, be independent, free of conflict of interest or close association with the company, and provide adequate security as required by the master to protect the interests of the company and its stakeholders. These safeguards protect the integrity and impartiality of the process. Once certified, the practitioner steps into the shoes of management. In fact, under Section 130, subsection 2, the board of directors is deemed dissolved. Full management and control of the company transfers to the practitioner in substitution for the board and pre-existing management. The practitioner must investigate the company's affairs, business, property, and financial position, develop a corporate rescue plan under Section 142 and publish it within 45 days of appointment, convene meetings of creditors and affected persons to consider and vote on the plan, implement the plan once it is adopted, and throughout, the practitioner is considered an officer of the court, accountable both to the court and the master. The Act also ensures accountability. Under Section 132, a practitioner may be removed from office by the court for incompetence, conflict of interest, or failure to exercise due care, by the master on statutory grounds, or if they no longer meet the requirements of Section 131. This framework keeps the practitioner focused on balancing the rights of the creditors, employees, and shareholders while giving the company its best chance at survival. So, when a company enters corporate rescue, it is the practitioner who takes the helm. They replace the board, manage the business, investigate the affairs, and chart the course through a rescue plan. It is a position of trust, a position of responsibility, and done well, it can be the difference between collapse and recovery.